first off, you will see that I think most of us know what is a will, but I probably give a little bit of definition so that it'll be easier for those coming to this talk. Now, a will is a document in which a person leaves instruction on the distribution of his assets when he dies. So why is this important? Is that when we write a will, sometimes clients will want to list all the assets that he has got at the moment. Now, if you look at the definition here, is distribution of his asset when he dies. That means we are talking about a person's asset at the time of his death. So sometimes it's a little bit meaningless for you to list all your assets now in your will, because your assets will change, right? So normally in a will, what we have is what they call a residuary estate clause. It means that you have a clause that says, whatever I have at the time of my death, I will give to so and so in whatever proportion. That will cover all your assets at the time of your death. But of course, sometimes people would like to give, let's say, his house, his car, or his shares to someone. You can always do that. But at the end of the day, you must say that whatever I have after I've given away a specific legacy, you must give it away in a residuary estate clause. Now, of course, we have to remember is that in my talk today, whatever that I talk about the law pertaining to wills, it does not cover Muslim and Islamic law, in which on issues of distribution of asset when a person passes away is different. For the Islamic law, he has got a different distribution, which I do not intend to go into. Now, this is what I commented. It will only take effect on death. All right. So sometimes that when you understand this, then you will know that you can always change your will. Let's say you write a will today, or maybe this month, and 2 years later you find that your asset pool changes, or your beneficiaries whom you give your assets to, you're not too happy, then you can always change your will. You can even change your will the day before you pass away. So it's only your last will that takes effect. All right, this is what I mentioned. So another question sometimes client asks is, is it necessary for me to write a will? What if I pass away without leaving a will? All right. Now, of course, I think now most of you will know that everything will not go to the government. But off and on, sometimes I still is faced with this question. Now, does all my money goes to the government? No, it doesn't. Right. If you die without leaving a will, we have a law called the Intestate Succession Act, which states that, look, when a person passes away without leaving a will, which actually previously was quite a majority of the people, then the laws on how your asset will be distributed, the rules pertaining to distribution applies. Right? I will go on the various rules. So when you die without leaving a will, it's called intestacy. That means a person died without leaving a will, and his assets will be distributed in accordance with the Intestate Succession Act. Now, this is the first rule. All right. So let's say if a person passes away, he has got a wife or a husband, no children or parents. So remember, that means the parents pass away and they do not have children. Then all his assets go to his spouse. So you're happy with it if you're a married couple and then your parents already passed away, they've got no children, everything that you have will go to your spouse. Now, what if you have got children? This one is quite simple. This is applies to quite a lot of people. If you are married and you have got children, 1, 2, 3, it doesn't really matter. half will go to the spouse and half will go to the children. Now, what if your spouse died before you? All right, that means you're talking about a married couple, then the husband or the wife passed away first. Then all his assets were distributed equally among all his children. So if you're happy with it, you don't have to leave a will, don't have to write a will. But of course, there are certain other considerations that we'll talk about later. Now, what if, let's say, your children are adult, they are married, and then they have got children, and this one of your child passed away before you. His or her share will flow down to his children. So remember, it's only when you have children and your children dies before you, living children, his shares will flow down to his children. Okay, the implication like this. Let's say, for example, you have got 3 kids, right? And one of your kids died before you, all right? But he has got no children. Now, then his share will not flow to anybody, but will be distributed among the surviving 2 kids. But if this child who dies before you has got 2 children, his share will flow down to his 2 children. Now, what if let's say you have a situation where you're married, right? You have no children, but your parents are alive, all right? Then your share will be so among half to your parents and half to your spouse. All right, for example, let's say if you're not married and your wife passed away, all right, and then your wife has got parents, all right, you are only entitled to half of your wife's asset. The other half will go to her parents. Okay, if you pass away, all right, and then you're not married, or your spouse dies before you, then you have got no children. Everything that you have goes to your parents, so it flows up to your parents. It flows up. So if you have got brothers and sisters, but you're not married, and then no children, your parents pass away before you, everything will be distributed among your brothers and sisters. Then if you've got no other relatives, that means no spouse, children, parents, or brothers and sisters, but you have got your grandparents are still alive, all right, your grandparents. Then if you have got no other relatives, your grandparents pass away, then it goes to your uncle and aunts. Only when you have no other relatives, no uncle, no aunts, grandparents pass away, only in that kind of situations, then the estate will go to the government. So you find that, look at these rules, it's very rare that you have got a situation where a person's estate will go to the government. So sometimes, let's say, if you wish to write a will, all right, then what I'm going to show you is a very simple will. Let's say if you want to make a very simple will, you can always do it yourself. The first sentence is, of course, you are going to put in your name, your NIC number, your address, and then you just say that hereby revoke all former testamentary dispositions made by me and declare this to be my last will. Okay. Why you say declare this to be your last will? Because only your last will take effect. That means whenever you write a new will, you automatically revoke your previous will. Now, this one is important. You have got to appoint an executor and trustee. The reason is this: if you pass away, if you die, all right, you want to write a will, somebody will have got to be appointed to execute your will. Take your will, go to the court to say that I'm appointed the executor, and you can collect all your assets and distribute according to your will. So you must appoint someone to do this job. All right. So sometimes people ask, who do I appoint to be the executor and trustee? The most obvious person should be the beneficiary, because the executor is not paid unless you provided a certain sum in the will for the executor. Otherwise, it's not paid. So if you appoint someone who is not paid and then he's not prepared to be an executor, no point, right? But if the person is an executive, is the beneficiary, of course, he has got a vested interest in going and collect your assets and distribute accordingly. It's not a must. What I'm saying is it's not a must that you must appoint the beneficiary, but it's preferable. Of course, secondly, of course, if you appoint someone to be an executor, you must ensure that he agrees to it. Otherwise, if you pass away, suddenly your will appears, and then this person caught by surprise that he's appointed executor, he can always say, look, I don't want. And then you'll be left, your will left without any executor. Okay, this is the residuary estate clause. This is the clause that I mentioned right at the beginning of my talk. And that is that I give the residue of my property after payment of all legacies given by me at my death and funeral and testamentary expenses to, you can have to 1 person, to 2 person, to 3 person, in equal share, in different percentage, up to you. Now, of course, remember is that when the person dies, you've got to pay his debt first. That means if you owe people money, owes the bank, you've got to pay first. Only after paying the debts, pay your funeral expenses, then the balance of whatever he owns will be divided among his beneficiary. So this is what they call a residuary estate clause. So this will cover everything that you own at the time of your death. You don't have to, that's what, you don't have to list out, say, my HDB flat, my bank account, my shares, because all these are covered. My property means all your property. Of course, sometimes people will say, okay, maybe I want to give $10,000 to my mother or one of my nieces. You can always do that. But you do that before this clause. This is what I call legacies. All my legacies. You can see all after payment of all legacies. So above this clause, you can say, okay, I give $10,000 to my niece, or I give my house to my husband, something like this. Right? Now, this clause is, people might ask, what is this clause? My trustee shall hold the said property upon trust to sell the same with power in his absolute discretion to postpone sale. This one is, let's say, for example, you have got a HDB flat, all right? Then, strictly speaking, whoever that is your executor should sell a HDB flat immediately and distribute to the beneficiary. But sometimes, it says maybe you give it to one of your children, and then you don't want to sell immediately because he's staying inside there, in the HDB flat. So this clause allows the executor to hold on to not selling immediately. All right. Otherwise, if you do not have this clause, you must sell it within 6 years. It's provided in under the in law, what I call Conveyancing and All Property Act, that says that if you do not sell your property within 6 years, all right, unless you are allowed to hold it for more than 6 years, then you must apply to court later on subsequently you want to sell. Okay, now this is the final what you call attestation clause. You have got to sign your will. All right, you can see that this clause says that it must be signed. You can see below, I'm not too sure whether it shows below the witness, there must be 2 witnesses. All right, you can sign your will in Chinese, in thumbprint, it is okay. But you must sign here, all right, anywhere. Sorry, gone, all right, and then before 2 witnesses. Right. So this is a simple will that those people who want to draft themselves, they can do it. Don't make it too complicated. Sometimes I've seen people who write a will, they say, look, I don't have any other thing, I only got a HDB flat. So they follow the same thing, but instead of using a residuary estate clause, they just say, I give my HDB flat to so-and-so. Fair enough. That is valid. Then the next question is, what happened to the rest of the property? Your money, your cash in bank, your shares, or your cash in your pocket. You do not have that. So if you stop at the clause where say I give my HDB flat to so and so without following to say that I give the residue on my property, and next time when the executor is I have to execute a will, then the court will ask what happened to the rest of the money, and then you will have a problem. It's not that the will is not valid, but then that means you have not given all your assets away. So part of your will be intestate, following the Intestate Succession Act.
Mr. Tan,
yeah.
Lily here. Just now, I think there are a lot of people wanting to see the will again. Can you show the slide?
Okay, then I have got to, why
go back.
don't I got to go back. At the end of it, I show it again, all right?
Okay, yeah.
Okay, at the end of the top, all right? Remind me then, I put it up and then I show it to them again. Okay, because otherwise, yeah, I got to go back, backspace. Okay, can you see that?
Yes.
All right.
Good.
Okay, so we can see if you do like this, you won't go wrong. All right, you do like this. But the problem is sometimes people do paragraph 1, they don't do paragraph 2. Paragraph 2, they change it to I give my HDB flat to so and so, and they full stop. All right, it is okay. But what happened to other assets apart from HDB flat? Right. So if you want to have another paragraph to say I give my HDB flat, fair enough. But make sure you got this paragraph 2 in. Right. Shall I move on? Yeah. Okay. So the question, okay, if it's will so simple, why do I need to make a will? Why can't I just follow the intestate succession? Yes, you don't need to make a will. You're prepared to live. Let the law decide how to provide. But sometimes people don't. Some people do not want to follow the Intestate Succession Act. Then the will give you flexibility. You can give to, instead of saying that I give half to my spouse, half to my children, you can say that, look, I give everything to my spouse. Then let her take care of the children. Then you make sure you write the will, right? Okay, now this one is a lot of people, honestly, is not aware of. Actually, once you have got executors and in your appointed in your will, actually you can deal with your assets immediately. All right, that means you don't really have to wait for a long time for the court. But strictly speaking, a lot of people will just want to wait until you get a court order, what they call a grant of probate. But by law, you have already appointed an executor to deal with that. Now, okay, this is also important. Now, if you do not have a will, then you have not appointed anyone to deal with your assets. But sometimes people say, I prefer to get one of the my closest relative, maybe my wife, or maybe my sister, who is more trustworthy to take care and distribute my assets. The will give you the flexibility to do that. Okay. Now that is remember the last clause I says that you can postpone sale of your property. Now the will allow your executor to postpone sale. Give your executor flexibility. Now I pause here for this executor having flexibility. Let's say, for example, your will you have 3 houses or something like this, right? And then you're supposed to be distributed amongst your siblings, let's say, or maybe 5 of your children, all right? Then even with this clause, doesn't mean that whoever the executor can postpone indefinitely not to distribute the assets, because that's not the intention of the clause. It's just for under depending on the circumstances. A few years ago, there was a court case where the executor, all right, in charge of I think about 4 or 5 commercial property, I can't remember how many, and then he just collect the rental and distribute among the siblings. Then the siblings are getting old, and then he didn't want to sell the house for the property for the next 5 years, 10 years, or something like this. Then the siblings say, we are getting old. We don't want just the rental. We want the proceeds of the sale. And then the siblings apply to court. The court say, yeah, you can postpone sale, but we need the number limit, not indefinitely.
Hi, Mr. Tan.
Yeah.
Apologies.
Yeah.
Navin here from Brahm Centre. A number of participants are saying that they can't hear you very clearly.
Okay. Yeah.
Your mic.
Let me see.
Thank you.
Okay. Maybe a bit too close. Would that be all right now?
Keep talking. You are a bit more muffled now.
Okay. So I'm a bit closer because I'm using a notebook. Would that be all right now?
Yes. So it's better now.
Okay. I was got to move a bit closer. All right then.
All right.
Okay.
Thank you.
Okay. So now this one is the last point is more of the administrative. Now, if you have a will, all right. Now, for example, remember I say that if you pass away and you have a wife and children, half will go to your wife and half will go to the children. If you do not have a will under the Intestate Succession Act. Now, so it is okay. Then your wife will apply to court to be the administrator instead of the executor. Now, the court will grant. There's no problem. We'll give it to you because the wife is the closest dependent of the deceased. But the court says, okay, your children, are they above 21? If they are below 21, then the court says, look, in the meantime, you are holding the children's share in trust for the children. So what if you run away and don't give it to the children? So the procedure is that the court will require the wife to produce guarantors, right? Sureties, we call sureties and guarantors, to say that, look, the wife is required to give the children share, and then if the wife run away, then the sureties will have got to be responsible for the money that the wife is supposed to give to her children, right? Now, if you have a will, you don't need a surety, because the court says that you have already appointed an executor, is the executor's job. But since if you do not have a will, then the court says, I'm the one who appoint the wife. The court is the one who appoint the wife as the administrator. So the court will want to ensure that the wife do not run away with the children's share. That's why they need. Of course, a lot of people, sometimes if the assets are maybe a few $1 million, where are you going to find 2 sureties? So you can apply to court for dispensation with this, which normally they grant. But that requires an additional step, additional legal cost to provide for this dispensation of sureties. That is why if you have a will, you save you a little bit more extra legal cost for this reason. But if your children are all adult, this one is not required. Okay. Now there are some practical issues on will that I think everyone ought to be aware of. Is sometimes I still see sometimes people write their own will and then they put in and say, look, I give my CPF money to so and so. No, the will doesn't cover that. The will is not allowed to cover that, because under the CPF Act, right? If you wish to give your CPF money to anybody, you go to a CPF board, nominate. Your nomination is like a will, right? So even if your will says that I give my all my money to my wife, your CPF money, all right? And then if you fail to make a nomination, CPF will not follow your will. CPF will follow the Intestate Succession Act and give half to your wife, half to your children. So it is very important, in fact, for everyone. I think most of us has CPF money. To go to a CPF is a very simple form. Just go to a CPF money. So go to a CPF, any of the branch, and then you make a simple nomination. It's a nomination form, and then there will be two of the officers with their witnesses, and then you can always change your nomination. If you nominate today, let's say next month you want to change and decide, say I want to give to somebody else, you can always do that. Okay, not to worry. And I think a few years ago, I have come across this WhatsApp message where it says, look, you will nominate now the CPF money will be locked in. No, if you will give to somebody else, the CPF money will be locked into your CPF, their CPF, but will not be given to that person. That is not true. If you come across this WhatsApp message, because when you pass away, all your CPF money will be given to your beneficiary in cash, unless you state otherwise. Is the reverse. That means, let's say, for example, you have got 50,000 in your ordinary account, 100,000 in your special account, and then 60,000 in your MediSave account. All these will be given in one chunk, one lump sum to your beneficiaries in cash. Right? They'll pay in cash. But the CPF form do have one part where it says, if you do not want to give them its cash, if you want to give it to them, ask the CPF to transfer to their CPF account, let them know. They will do that. By default, you'll be given in cash. All right, now this one is Section 73 of the CRPA insurance policies. I think some people, quite a majority of the people who have insurance policy, life policies. And if you have a life policy, let's say you got it maybe 5-10 years ago or something like this. Now, sometimes your insurance agent will say, hey, why don't you nominate your beneficiary as your children? All right. So, but hopefully the insurance will explain to you the legal implication of this nomination. Right? But sometimes they don't. And they don't understand what is the legal implication. For example, let's say you have a life policy, 100,000. When you die, you nominate says, I give my beneficiary will be my children. You know what happened? The policy no longer belongs to you. It belongs to your children, right? So that means that it is your children's money and it's not your money. And if it's not your money, when you pass away, it will not be covered by the will. They will give it to your children. The reason is that once you nominate your spouse or your children, you created a trust. A trust means that you already given away these proceeds while you're alive. It's no longer yours. Okay. The practical effect will be, let's say, for example, for educational policy, and you nominate your children to be the beneficiary. You know, when the educational policy will mature in probably when they come to 1 year old or whatever, what will happen? The insurance company will send a check to your children or not to you, no, because you have given it away. So remember this. If you're not too sure, check with your insurance agent. Okay, real properties. Real properties, what we are talking about is, let's say, your HDB flat, your condo, your landed property, or whatever. These are what we call real properties. Now, sometimes husband and wife, when they buy a HDB flat, the HDB will say, okay, you or your lawyers will say, how do you want to hold your property? Is it joint tenancy or tenancy in common? Now, you must understand the legal significance. Let's say you hold your property as a joint tenant. Right? What it means is that one person passed away, the surviving person will take the whole property. So that means it doesn't go to your will. You say that, look, my share of the property I want to give to my mother. No, it doesn't work that way. If it's joint tenant, all right. If it's tenancy in common, yes. Tenancy in common, that means you and your husband or whoever you share your property, you will, in the title deed, you say each one 50-50 or 60-70, 60-40, 30-70. So your share of that will be covered by your will. So if you have a property, take a look at the property, whether it's joint tenancy or tenancy in common. Very often for husband and wife, it will be probably joint tenant lah. If you put tenancy in common, then your wife will probably be asking, what are you trying to do? You know? Half your assets, half of your property you want to give to somebody else. Okay? And then you have a lot to answer your wife. Good luck to you. Right? But this, what I want to point out is that your will not cover properties that are owned jointly. It will go to the other part, the other surviving owner. So remember that. Right? But of course, sometimes people say, if that's the case, then I don't want, no. So I want it to be split half, no, because my half I want to give to somebody else. You can always do that. All right, you can always go get a lawyer or a HDB to go and split the share to half. Then it's common. And once you have done that, your half share will be covered by your will. You can give to anybody you want. This is what I meant by joint cash in the bank. Okay, now this one, if you Google, sometimes you'll see people go to court to fight over cash in the bank that held in joint name. So it's always a potential problem. Let's say, for example, you have a joint bank account with your wife, all right? So the question is, you say I give all my money in my bank account or whatever to say maybe you don't give your wife, you join, you give your sister or whatever, right? So does the sister has got a share in this cash in the bank that's held in joint name with your wife, right? Now, it is joint names in cash is different from real property. Real property, the law is very clear. For cash in the bank, it depends on the relationship and what is your intention. So that's why it causes potential problem. For example, let's say you have older folks, they have got sometimes they have a joint bank account with your children for convenience. They say, look, I want my son to take care of my bank account, not to give it to him, but help me draw the money. Now, if that is expressly very clear, all right, then when the old lady passes away, the money doesn't go to the son because he already says it's just for him to manage, all right? Then it will goes to, depends on it will be added to his asset pool, right? But if the old lady doesn't say, we don't know what's her intention. So how? Then you go to court and fight, right? Then when you do that, then the court has got some way of looking at the joint account. One way they call presumption. They'll presume that if it's a joint bank account with husband and wife, all right, the intention is to give to the husband and wife because of their close relationship. That's a presumption. If it's parents and children, they also apply that kind of presumption. But presumption is rebutted if it's what I call rebuttable presumption. That means if it's expressly set out somewhere that says, look, no, it's not to be given to a joint account owner, then that presumption doesn't hold. So when I write wills for my client, I always ask them, okay, what do you want to do with the joint account if you have better state in the will? So that will prevent people from arguing. So for example, you have got joint account with your wife, you say, okay, my joint account with my wife, I give it to her. All right. If I joint account with other people, no, not to be given to other joint account holder. All right. It's to be added to my residuary estate to be distributed according to my wish, the residuary estate. So that makes it very clear. All right. Otherwise, once in a while, joint cash in the joint bank account, joint names, end up in court. All right. One case about 5-6 years ago was the father-in-law have a joint account with the daughter-in-law, right? Then a couple of 100,000, quite a lot of money. Then the daughter-in-law says, look, actually, the father-in-law intends to give it to me, But then the rest of the children say, no, actually it's for convenience sake. Then you go to court to fight, then you see what's the intention of the old man. So the court held that, look, it is for convenience only. So they take the money in the cash and then give it to the beneficiary of the estate, not to the daughter-in-law. But if you state it very clear in your will, this sort of thing will not happen. Okay, estate duties. Right? Sometimes people ask and say, look, my assets is there. Is there any estate duty? So for the moment, I'm telling you, because I think maybe the government might change the law. The law has been changed since 15th of February 2008. They abolished estate duty. All right, but we don't know what will happen in future. So don't worry, you can have 10 million, 100 million, no estate duty. One of the consequence, anyway, consequence of this is that, let's say, for example, if you've got a house, all right, that you say you give to your wife, right? Maybe it's your sole name. So when you pass away, the house will be transferred to your wife. There's no estate duty, no stamp duty, no ABSD, just transfer to her. Pay $10. You just pay some legal fees to help the transfer. That's all. Very simple. All right. That is a consequence of that. Then finally is, what is the difference between a will and a gift? Remember just I said about the insurance money. Insurance money, when it says I give it, my beneficiary is my wife or my children, actually you're giving your insurance money to your wife while you're alive. All right. Whereas a will, you only make the gift when you die. So that's a very important distinction. All right. Let's say, for example, a very rich man, he goes, he announced to everybody, say, hey, I'm giving all my assets when I pass away to charity, All right. Well and good. I mean, that's when he passed away. All right. But he's not making a gift now. That being the case, he can always change his will. If he says that today I write a will to give all my assets to charity, but next day he changed his will to say give all his assets to somebody else. The charity don't get anything. So okay, there are some of the common questions I ask me. What happens when a person to whom I make a gift dies before me? Okay, because let's say, for example, remember right at the beginning, what did I mention about the children of your children, right? The gift lapses and goes to a residual estate. Okay, let's say, for example, you write a will. You say, I give my house to my sister. All right, my sister. All right, and then your sister died before you. Right? Then what happened to the house? Okay, you won't give to no point giving to your sister already. It lapsed. And then remember there's a residual estate because I give everything that I own to somebody else. That somebody else will take the house. All right.
Hi, Mr. Tan.
Yes.
Apologies, Navin here again from Brahm Centre. A number of participants are requesting that you speak directly into the mic again. Your voice seems to be I believe it's if you face towards
my mic now. Okay.
Your mic is maybe to your left. Every time you look to the left of your screen, it's clearer.
Okay. To my left,
Yes. And yeah, if you just look towards one direction, so every time you move, I think it's not picking up your voice clearly. Okay. So sorry about that, Mr. Tan.
Yeah, it's okay. It's all right.
Thank you.
Okay, thanks. Okay, now go on. All right. So now, what if the gift is to your children? Remember what I said right in Intestate Succession Clause? You give to one of your children die, it goes to your grandchildren, right? This is why this also applies to the will. All right. For example, in your gift, the house that I mentioned, you say, I give my house to my son. All right. And then if your son passed away before you, and if your son has got 2 children or 1 children, okay, this gift to your son will flow to his children. But if he has got no children, some people go, oh, what happened? Will he give to his wife or not? No, it doesn't. It only goes to the children. So not to worry, it will not go to the spouse. Right? It will flow to only the children. Okay, can someone below 21 years old make a will? Yes. No, I'm free. No. The answer is no. Because unless we change the law to 18 years old or something like this, a person who is only above 21 years old is deemed to be an adult. And a minor is not allowed to enter into any contract, things like this, so including making a will. Who can be a witness? Remember, I gave the form, the simple format for the will, and then there's a requirement for 2 witnesses. All right. So who can be the witness? It must be, of course, 21, above the age of 21 and of sound mind. Right. And must not be a beneficiary name in the will. Okay. So what it means is that if any of the let's say, for example, any of the beneficiary name, let's say your son or your friend, you give some money in your will, you cannot make you cannot make him, ask him to be a witness. Right? Not the wife or husband of the beneficiary. For example, let's say in your will, all right, in your will, okay, you give to your daughters or your son, all right, don't ask their husband or their wife to be a witness. Otherwise, your gift to your daughter or your son will be void. Can an executor be a witness? As long as he's not a beneficiary, okay, yes, he can, okay. But if he's a beneficiary, the gift to him will be void. What happens if I marry after having made a will? All right, you have got to make a new will. Because the law presupposes that after you marry, you must think of providing for your wife, right? So automatically, after you get married, you must go and make a new will. Unless there's such a thing as called will is made in contemplation of marriage. That means you make a will just about you're going to get married, and then you say, okay, I'm going to provide something for my wife. Then that's okay. But very rarely people do that. Easiest thing is after you get married, make a new will. Can I write my will in Chinese or any other language? Yes. Okay. Yes, you can write in whatever language, but of course you make it things a little bit difficult for your executor because in Singapore, our language of the court is English. So if it's any other language, you will need to translate it for it to be admitted. Okay, so that concludes my talk on will. I will deal with that Q&A later. The next part of will is lasting power of attorney. Okay, remember when I talk about a will, everything that I say, all right, only take effect when you pass away. Right? So don't confuse. A will is a document that doesn't take effect immediately. All right. So that being the case, all right, you can always change your will. Right? So remember, is the will is a document that only take effect when you die. Because a lasting power of attorney is different. Okay. Some people ask me, say, hey, I already got a lasting power of attorney already, well, I don't need a will. So lasting power of attorney is different. Lasting power of attorney is the documents that take effect when you lose mental capacity. Okay, remember that. It's a document that don't take effect immediately, right? Just like a will. But it only take effect when you lose mental capacity. Like for example, you have got Alzheimer, you get into a coma due to stroke or whatever. All right. So it only take effect when that kind of thing happens. Again, it's a document that don't take effect immediately. But once you die, lasting power of attorney doesn't work anymore because you don't require that your will kick in. Right? Now, don't confuse a lasting power of attorney with a power of attorney. A power of attorney is different. A power of attorney is while you are mentally sound, no issue, you ask someone to sign some document, take care of something for you while you are mentally capable. Right? So you have got three documents. One is while you're mentally capable, that one it takes effect immediately. You have a power of attorney. Then when you lose your mental capacity, lasting power of attorney. When you die, the will. 3 stages of your life. Okay. Now this one is something I carried from to emphasize the importance of having a lasting power of attorney, because you say one in 10 people over 60 in Singapore have dementia, 10%. I think when you go to 80, the percentage goes up to 20, 30%. Right? So what is an LPA? A legal document under the Mental Capacity Act. So remember, it's not a normal power of attorney. Right? So it allows a donor, A person is called a donor, to appoint B to look after A. All right? So you say, okay, to look after what? All right? So it's to take care of his personal welfare and property if he loses mental capacity. Right? So it is a power attorney to say, okay, if I lose mental capacity, I've got Alzheimer, I cannot take care of myself, I got coma, suffer from stroke, I don't know what I do, then this person will step in, okay, if you are given him an LPA, and he will have power over your personal welfare and property. Okay. Personal welfare, then what do you mean by that? Right? What are the terms? Personal welfare. Okay, personal welfare means where to live, day-to-day decisions, handling your letters, who you may have contact with, healthcare and medical treatment decisions. So mainly a lot of time is healthcare and medical treatment decisions that are quite important. All right. So this is what I call personal welfare. So covers everything that you can do yourself. All right. Can make decisions yourself. He will do it. He will step in and do it for you. And property and affairs. Okay, manage your property, bank account, CPF monies, purchase equipment for your use. So all your assets, CPF money, even insurance money, the work is managed. Right? So that means take care of your money. So you can see that this person is very important. Now it is equally important for you, because if you are unable to do it, how are you going to manage? Get your money in the bank account to look after you, take your CPF money. How are you going to do it? You can't. You go to the bank will not allow you to withdraw because you don't know what you're doing, right? Okay. Now, some people might ask me before I step on who can be a donor and donate, is why must I do an LPA? Now, can't the bank just can't my mother or my wife take care of me, step in and do it? They cannot. All right, the law doesn't allow that. So it doesn't mean that when a person loses mental capacity, the wife or the husband or the children automatically has got a right. So in order to get a right to take care of you, if you don't have an LPA, you know what will happen? You know what happened is you have got to your closest relative, that means your wife or your children, have got to apply to court, right, to be appointed the attorney to look after you, and then for this, okay, the court, it will be probably a more involved process, take about 3-4 months, 4-5 months, and it will probably cost you quite a lot of money, $5,000, $10,000, right? And it depends on your assets and the kind of things that your attorney need to do for you, and the court will restrict the attorney on what they can do. So it is very laborious for them. So the best is you do a simple LPA, they can take care of everything. Right? Who can be a donor and donee? It must be above 21 years of sound mind sibling. If it's a minor, he can't take care. You cannot appoint someone to be your donee to take care of you, or neither can you be the one who can take care of others. Okay, bankrupt. Okay, if you are a bankrupt, doesn't mean that you cannot appoint someone to take care of you. But only thing that the other person, whoever that's donee, cannot take care of your property, because if you are a bankrupt, right, all your assets will go to the official assignee, whose job is to take care of your assets to pay your creditors. Right? So for a property, they can't do it. If the donor and donee is married to each other and divorced later, you must appoint the OPG. OPG is the Office of Public Guardian, and his appointment is revoked. So what is the implication of this? Okay, let's say, for example, you appoint your wife to be your donee, that means to take care of you when you lose mental capacity. Then after that, your marriage get into trouble and then you are divorced. Do you think that it is wise for you to continue to appoint your wife, your former wife? Not a good idea, right? Appoint husband also, because I think the divorce probably you'll be killing each other already. So then that's why the rule says that you automatically revoke and you should go ahead and appoint someone else. But of course, you can still go ahead and say, no, I still want to appoint my former wife or former husband. Go ahead, reappoint again, appoint your former wife or former husband, if that is your wish. Okay, what is the donee's duty? Donees, remember, is a person who are appointed by you to take care of you, right? The duties. Okay, remember their powers come under this Mental Capacity Act. So it says Section 6. This is Section 6 of the Mental Capacity Act. It said the donee duties, whatever they do, must always be in the best interest of the donor or the person. I think that's pretty obvious, all right? Is that the person lost mental capacity. He don't know what he's doing. He appoints someone who he thinks can look after him. So the person's duties is a fiduciary duty. So since the person, the donor, put all the trust in me, it's my duty to make sure that whatever decision I make is in his or her best interest. Okay, then there's another basic principles, all right, is that you must allow the donor to make decision if he's able to do that. Sounds a little bit funny, but there is a important legal principle involved. Is this: you must, for the donee, you must treat the donor as a person. Although he lost mental capacity, he is still a person with a mind of his own. Although his mind might be clouded or whatever it is, right? So if there's a situation where he can make a decision, you must allow him to make decision, right? For example, let's say Alzheimer. When a person is in the first stage of Alzheimer, sometimes they are just very forgetful, but they are still sane in some respect. So they say, look, today I want to go and see a show, or I want to go to hawker center and eat char kway teow. I mean, if you can make the decision, you must allow him to do it. You can say, no, I got no time. I don't allow you to do that since I'm in charge of you. Can't treat him as a small boy, right? That is what this basic principle is about. Fiduciary duty. Okay, now when you are in charge of somebody's money, you always hear this word fiduciary duty. All right, that applies to directors of company. If you're in charge of company's money, the company's money, you have a duty. Fiduciary duty means that you must protect whatever that is entrusted to you, the money. All right, you must not take advantage of a position and in the conflict of interest situation. Take advantage of a position will be like this. I think all of you, most of you will probably remember many years ago, I think probably now 6-7 years ago, the tour guide case, where the tour guide was Donee, was appointed by the old lady, right? And then he realized that the old lady got a lot of money. He take the money, spend on his own, spend on his own family, go on holiday. And then when he tried to go and sell the old lady's, I think, bungalow for 30-40 million, then the niece got wind of it, report to the police. And what happened? The tour guide went to jail. All right. Now, because he's the donee, he takes advantage of his position as the donee, and then use the money for his own, not for the old lady. All right. Conflict of interest. Now, if conflict of interest would be like this, I give a very simple example. Let's say, for example, you are the renovation contractor, all right, and then your mother lost mental capacity and trusted you to look after her HDB flat. I said, okay, if that's the case, since I'm a renovation contractor, since the house needs to be renovated, I appoint myself. That is a conflict of interest, right? You should not do that, even though that you might say, hey, I'm going to charge my mother very cheap. But at the first principle already, you should not be appointing yourself, because you are the one who negotiate with yourself what is the best deal. So that is a conflict of interest. Now, finally is this. Sometimes with all these best interest principles, and I say, hey, when I'm put in that position, how do I know whether I'm acting rightly or wrongly? Okay. Now, the Office of Public Guardian, which is the government department in charge of this, they have produced a code of practice. Okay, all you need to do when this happens, you go to the Office of Public Guardian website. There is a code of practice. Now it's digital. You download that. It will give you various scenarios where you can and cannot act. But what I'm going to tell you is that please do not rush to go there and look at the code of practice, because it's not going to serve you any purpose. You only do that when you are put in a position where you have got to act as a donee. All right. Now, basically, I think all you need to do is remember when things happen. All right. As long as every decision that you make, think of the donor's interest, generally you're quite safe. Okay, there are certain things that, of course, the donee cannot do, cannot execute a will. That means, for example, okay, you say, now I'm in charge of him, I can write letters for him or her already. Now maybe I can write a will on her behalf, and then I'm going to give everything to my children or something like this. They're not allowed, right? Make CPF nomination, same thing. You cannot go to CPF, say, now I'm in charge already, I'm going to make nomination on his or her behalf and then give the money away to charity or to other people. You can't do that. Okay, so now I'm not too sure whether I got time. If you look at the standard form, there's one section where it says that, look, whether you allow the donee to give your money away. Okay, unless you take that, otherwise you're not allowed to give the money away to charity or whatever. Okay, now this one is quite important to a lot of people. That's why it's specifically provided in the Mental Capacity Act. It says that if you are the donee and in charge of take care of the person's personal welfare, that doesn't include changing the religion. Okay, for example, let's say if you're a Christian and then the donor is a Buddhist, you say, okay, now I'm going to help the donor by changing his religion to be a Christian. You're not allowed to do that. This one is quite important to a lot of people. Okay, then you've got things like advanced medical directive. I'm not too sure whether, I think probably most of you or some of you might know this. Okay, we have got, this has been in our law for quite some time, is that while we are of sound mind, we can sign a form called an advanced medical directive, which states that if I suffer from terminal illness, please don't continue treatment. Okay, so there's an advanced medical directive. Remember, I said that as a donee, you can make medical decisions. The medical decision actually includes whether to put a plug or not. All right, but if you have got an advanced medical directive, please, when I suffer from terminal, please don't continue to treat me. If the donor has already done that, you have got no right to say, no, I want to continue treatment, because he already. I think later on, Lily will talk a little bit about the advanced care planning. Okay, now the advanced care planning is to complement the LPA. Now, then Organ Transplant Act, I think, I'm not too sure whether you're aware or not, by default, if we die of an accident or whatever it is, that the government got a right to take our organs, right? Unless you opt out, right? So I think a lot of people don't opt out, but you can opt out. If you already opted out, the donor opt out, you cannot opt in for the donor. Okay, let's say you do not want to be a donee, you cannot say, no, I appoint somebody else to do it. Like, okay, just now, remember when we were talking about the medical issues, okay, you look at normal medical treatment, life-sustaining treatment, and clinical trial. Okay, these are actually specifically set out in the form, all right, which will allow your donee to make decisions on it, whether to continue treatment or maybe, let's say, to try put the donor on a clinical trial. Okay, these are the powers that we are allowed to do. But remember, for all medical issues, okay, when you want to make medical issues for the donor, you must consult the lawyer. No, sorry, consult the doctor, because the doctor is the best person to advise you. Right? Don't go on the internet and or go on YouTube and say, oh, I find something, no, this treatment will be better, no, because you must make a decision to the best interest. And I do not think that that is in the best interest. If your doctor say A and then you go to the internet, you saw B, you say no, I prefer B. That I don't think that would be the best interest of the donor. This one is when you want to the donee want to perform duty. Okay, it's a code of practice, mental capacity, and the doctor specialist report. Finally, is this doctor specialist means how to know whether you have got a power. All right, it's only when you got a doctor's report that to say that the donor has lost mental capacity. You send it to the Office of Public Guardian, then you can act. Okay, this is a website.